USCIS issued an internal memo which was not made public on March 7th, indicating that they will no longer approve applications for advance parole for anyone who entered the United States without inspection. Doesn't matter if this is through TPS advance parole, DACA advance parole, asylum pending advance parole, or any other type of advance parole. I personally learned this information when one of my colleagues was applying for DACA emergency advance parole for one of her DACA clients to leave the United States to visit a dying family member. And the USCIS office in New York City specifically told her, "We've received an internal memorandum on March 7th indicating no more advance parole and emergency advance parole for anyone who entered the US without inspection." Now, I understand this policy, but what could the only reason for this be? The only reason could be that they do not want people who are in the US to fix their entries. So in past videos, I've explained advance parole and other forms of parole, like for example, military parole in place where you don't have to leave the US, you can just apply for it. The government waves its wand and now your entry has been fixed. So these ways of parole, the purpose of it, when somebody is in the US and they entered the US without inspection, they will not be eligible to apply for permanent residence through the adjustment of status process inside the US through a family member. So let's say, for example, you entered the US without inspection. You entered illegally through the border. And then a year later, you meet the love of your life, who happens to be a US citizen. You get married and you want to apply for adjustment of status. So your US citizen spouse would file a family petition, and based on that, you'll apply for adjustment of status. You wait a year, you attend your interview, everything goes well at the interview, they believe the marriage is real. But then 2 months later, you get a denial decision from USCIS that said you did not meet the inspection requirement for adjustment of status. What do? So now there's only two options really. One, we can transfer your case to a consulate abroad and you'll have to leave the US, go to the consulate interview, and then re-enter with permanent residence. However, the problem with that option is if you've been in the US for more than 1 year unlawfully, which in this example, my client has, you will need an unlawful presence waiver before you leave the US. That'll take 4 years to process, and the chances of success really depend on whether or not you can prove that your spouse or parent who's here legally will suffer unusual hardships if you're unable to return to the US. So if everything is perfectly normal in your lives, if your spouse or parent who's a permanent resident or US citizen, it's completely normal, they're not gonna suffer any more hardships than an ordinary spouse or parent would, you're probably not gonna get that unlawful presence waiver approved, and you're not gonna be able to leave the US, because if you do, you're gonna get stuck there because you'll be inadmissible because your unlawful presence has not been waived. I understand if this is the first time you're hearing this, that's very complicated. I've made videos where I break this down, but basically that would be the first option. And then the second option would be you need to fix your illegal entry in some other way so that you can reapply for adjustment of status. And that is where parole comes in. So there are several types of parole. The most common ones are where you apply for advance parole because there's an emergency abroad. Let's say you're from Mexico, you have a really old grandparent, and you want to go visit them before they die. You would apply for emergency advance parole. It takes a few weeks to a few months depending on the situation. You would leave the US to visit your dying grandparent, and then you would re-enter the US with inspection. And now you'll meet the inspection requirements. If you want to reapply for adjustment of status through your marriage to your US citizen spouse, you will now be eligible if you meet all the other requirements. And there are even some types of parole referred to as parole in place. For example, military parole in place. If you're married to an armed service member in the army or whatever branch of the armed forces, you can apply for parole in place, which basically means the government will just deem you to be paroled, which means you're now eligible for adjustment of status because you meet the inspection or parole requirement. Anyway, guys, the only reason USCIS would implement this policy is to stop people from fixing their immigration status. It's pretty on brand with the Trump administration. For everyone who said he only wants to deport the criminals, think again. That's clearly not what's happening here, and it wasn't what happened the first time around. If you bought that, that's on you. Anyway, guys, I'll keep you updated as new developments arise with internal policy memos or publicly announced memorandum like the one I mentioned last week. If you're new to my channel, my name is Pouyan Darian. I'm an immigration attorney licensed in New York. I practice immigration law nationwide. If you need any assistance with family-based immigration or naturalization, be sure to contact me. My information is in the video description below. If you're interested in learning more about family-based immigration, or you want to learn more about Trump's immigration policies, or other topics that might arise that are immigration related, be sure to subscribe. I put out at least 5 videos a week, and I'll see you guys next time for another video.